Hey, 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 good people! Here we go. Part 3. For those that are still hanging around, I didn't give you a headache. Shit is freaking like 1:30. I haven't eaten yet. I should probably go get something to eat. I'm getting kind of grumpy here. Chewing out my viewers. Stupid questions. Here we go. Part 3. Compared to Miranda. Do not confuse. Did I already do this one? Incident concluded it was, tone of voice. Okay, yeah, so I got to go to this page. Here we go. Emergency lights. Now, emergency lights is a detention. When a cop activates his emergency lights and you stop, most people feel they're not free to leave. You are detained. And if they activate their emergency lights, then they need to have reasonable suspicion and or probable cause. So I cannot do an essential counter with my lights. I cannot turn on my overhead lights, hit my siren, whoop, whoop, woo, and say, hey, dude, you got the time? That is not a consensual encounter. Because as soon as I activate my lights and siren, most reasonable people will think they are not free to leave. Now, I don't know what they're going to say in this, but let's see. Emergency lights. Shining. Oh, I got a phone call. Hang on. That's damn spam. You know what? I'm going to go get something to eat. I'll be back. All right, I'm back. Jeez, I went and did like 14 projects. What time is it? It's like 3:30 now. I don't remember what time it was when I stopped. All right, let's go. Let's start with emergency lights. Shining emergency lights at a moving or parked vehicle is essentially a command to stop. I don't know about that. Emergency lights. Okay, I was thinking a spotlight. Putting your spotlight on somebody is not a detention. Putting on your emergency red or blue lights, meaning you're required to yield by law, that's a detention. So shining emergency lights, that's not the spotlight. At a moving or parked vehicle, essentially a command to stop will result in detention if the driver stops. If he runs off, we don't have an unlawful detention because we don't have a detention. A reasonable person to whom a red light from a vehicle is directed would be expected to recognize the signal to stop and otherwise available for the officer. Or, as the Supreme Court put it, certainly few motorists would feel free either to disobey a directive to pull over or leave the scene of a traffic stop without being told they might do so. Meaning, if they don't think they can leave unless they're told to do so, they're detained. A detention will also result if the vehicle was parked and occupied, which happens a lot. See a car parked in a parking lot, pull it behind them, turn on the lights. You can run the plate, either it's private property, no cars are supposed to be there, you see the car moving around as if somebody's being raped or you're having sex, or you see a bong, somebody lighting up a bong or heating up a crank pipe or using a flame on a bent spoon. Any of those things would be like, okay, this guy might be doing drugs, might be up to illegal. So, attention will result if the vehicle is parked. Attention will not, however, result if it appeared that the lights were directed at another vehicle. So, that's a defense. If you think that you're detained, you pull over, you can say, I thought he was talking to someone else. And you can use that all the time when you failed to yield. You know, I pull up behind somebody and, the call gets canceled. They refuse to yield. I pull them over and go, why didn't you pull over, man? You were blocking me. Well, if you were going to emergency, why did you have time to stop me? I go, shut up, you big dummy. The emergency was canceled. That's why I got time to stop you and answer my damn question. Rick, you can't talk to people that... Shut up. I was in 4 cameras and shit. So anyway, they say, I didn't see you. By the time I saw you, I pulled over and then you pulled in behind me. So I only pull over when I saw you. Before that, I didn't see you. So now I'd have to prove that they did see me. But now with dash cams, it's a lot easier to prove that. You see them hit their brake lights automatically because they see the lights. They're like, oh shit, let me slow down. They hit their brake lights. You see the rearview mirror. Their eyes go up to the rearview mirror. They look to the rear. You see them flip you off out the window like, fuck you, I ain't pulling over. So when you got evidence, it's easy to prove that they intentionally did it. Before that, it's pretty tough to prove a failure to yield. If it appeared the lights were directed at other people. Has the court put it in Lawrence v. U.S. pedestrian who noticed a patrol wagon's emergency equipment ordinarily is not likely to know that an officer is signaling for a stop until the officer communicates it in a more direct manner to the pedestrians. The officers intended to stop. Whatever. Hell, that's too damn hard to read. Spotlights, high beams. It seems to be a general rule that a seizure will not result merely because an officer utilizes his white spotlight or high beams to illuminate a vehicle. Although a person who is illuminated by white lights might conclude, wrongly, they might conclude that he or she is an object of official scrutiny, a detention will not result so long as the apparent objective of the officer was to illuminate the area for officer safety. Has the Eighth Court explained in U.S. v. Mayberry, RFD, the act of shining a spotlight on a vehicle from the street was certainly no more intrusive than knocking on a vehicle's window. So, with that logic, if an officer walks up and knocks on your window, you are not detained. You don't have to roll down the window, and you don't have to stop because you're not detained. It says so right here. You can quote it. For example, People v. Perez, San Jose police officer. San Jose, man, they make a lot of case law in California. There's some buck wild. I mean, it's kind of a rough area, and they got their share of crime, but dude, San Jose usually gets a lot of money, a lot of new toys, and they kind of set the stage. I think they might have been the first ones to have computers in their car, first one with cameras. I mean, San Jose is kind of a hopping department. San Jose police officer on patrol spotted two men in a car that was parked in a unit or in an unlit section in the parking lot. And the reason why I'm misreading these words because I'm looking up here. You guys can't see it, but right above here is my timer. So every once in a while I glance up here to see my timer, to see where I'm at in time. And then I try to keep reading and I glance up and then I come back. So for all you idiots that are like, man, you need to slow down. You read too fast. I can't keep up. You misread that word. You mispronounced that word. You didn't put not. Jesus Christ, people. Make your own damn videos if you're so freaking perfect. All right, I digress. Unlit section in a parking lot of the motel that was known for drug dealing. Now, just because a cop says known for drug dealing, we have to show why we believe that. And it's pretty easily. You know, in the last year, there was 14 arrests. In the last year, 4 officers had to call for assistance because of foot pursuits and drugs were found. In the last year, we did 13 search warrants on the hotel with different rooms, with different occupants, and we found drugs. So when you say known for drug dealing, that's how you would justify that statement. And that's how you articulate why you believed, what you knew, when you acted. Okay, as the officer stopped behind a car, he turned on his high beams and a white spotlight to get a better look at the occupants. Now, cops know that if I spotlight you, most people freeze like a deer in headlights. Oh shit, it's the cops. So they either make furtive movements and try to hide shit or grab shit, or they freeze and they don't want to do anything. And hey, I didn't detain you. I'm just lighting you up. Now I'm going to walk up on you. It's still consensual. Yo man, what are you guys up to? Still consensual. Yeah, I see you parked in the parking lot. Figured I'd come by and say hi. Do I have to talk to you? You don't have to talk to me. I mean, hell, you're not detained. You're free to go. All I'm doing is trying to figure out why you're in the parking lot. Well, if I'm free to go, can I leave? I already told you you're free to go. Of course you can leave. I'm still trying to figure out why you're in the parking lot. No detention has taken place yet. No court would find that was detention. Now, if he puts the car in reverse and I go, whoa, 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 dude, you ain't leaving. Put the car in park. Now we have a detention. To me, it's a pretty simple concept, but I've seen a lot of cops make a detention afterwards. I'm like, dude, why'd you detain him? I didn't detain him. It was consensual. I go, dude, that was a freaking detention. I backed you up. You patted him down. You sat him on the freaking curb. You told him he could leave. I mean, dude, that was a detention. I said, if it was me, I wouldn't feel like I'd leave. Well, that's you. I didn't say he was detained, so he wasn't detained. I'm like, all right, whatever. So, you know, I mean, look, you can't get into trying to educate, control cops. If I was talking to a cop that way and question a cop, it's because I knew him, we worked together, and I was just giving him shit because I know he was wrong, and he didn't know he was wrong. So I was trying to give him shit in an education moment. Let's see here. He subsequently arrested the driver, Perez, for being under the influence of PCP. So, if he arrested him and all he did was shine his spotlights, when did the detention take place? Or when did the custody take place? When he told him he was under arrest, unless we find out more. He subsequently arrested the driver being on the influence. Perez argued that the spotlight and high beams would have caused a reasonable person. First of all, Perez didn't argue anything. His public defender, paid for by the taxpayers, probably for the 37th time he's been arrested, made this argument. So when you hear all these arguments like Miranda was a piece of shit. He ended up getting killed and stabbed in prison. He was a piece of shit. But his lawyers fought using his case and his name. Therefore, we had case law, Miranda versus, I think it might have been Arizona or something. But anyway, that's how you get these names in these case hearings. So Perez argued, Perez is paid for public defenders. Perez sat there like an idiot in jail because he freaking didn't know any better. Perez argued that the spotlight and high beams would have caused a reasonable person to believe that he was being detained. The court rejected that argument, saying, while the use of high beams in a spotlight might cause a reasonable person to feel himself the object of official scrutiny, such directed scrutiny does not amount of a detention. It should be does not amount to a detention, I'm thinking, but maybe of a work. Okay, similarly in People v. Franklin, an officer on patrol in a high crime area. How do we know it's a high crime area? Because the cop said so. Well, when he gets on a stand, the defense attorney is going to go, Detective Gore, in your report, you identified this as a high crime area. Why did you do that? Well, because, I've been working here for 6 years, 3 years. I've made over, 100 arrests for drugs and guns and violence. There's a lot of gang activities. It's a project of a gang injunction. There's 2 different gangs that have different turfs in the area, and calls for service in that area is higher than anywhere else in the city. That's why I call it a high crime area. Any other questions, Mr. Defense Attorney? I wouldn't have said that, but I would have said it by my answer. Anyway, so let's see. Where was it? Franklin Officer Patrol, high crime area, spotlighted Franklin as he was walking on a sidewalk. Very common. We do that all the time. And sometimes we get responses. My one buddy in Solano County, we were working together one night. We're in this ghetto cranker or crack neighborhood. He pulls up next to this girl walking the street, puts his spotlight on her and go, hey, baby, you got any crack? Shut up, motherfucker. I ain't about you. Get that motherfucking spotlight off me, motherfucking pig. Fuck off. And then we drove off. So, was that an unlawful detention? No, we didn't detain him. I was freaking laughing. We just drove off to the next call. But anyway, I digress. Oh, Frankie, he was a character. Anyway, let's see. Franklin was wearing a full-length camouflage jacket. So what? Oh, wait a minute, I missed that. Okay, so he spotlighted Franklin as he was walking on a sidewalk. Okay, why is that odd? Maybe it wasn't odd. Maybe he was just spotlighting him to see what he was doing. Maybe he was spotlighting him to see if he's got direction. Maybe he was spotlighting to see if the guy threw a gun on the ground and took off running. There could have been a million reasons. Remember, earlier, we found out, doesn't matter why he spotlighted him. Doesn't matter if it was a woman with a cute pair of little tight skirt and he wanted to check out her skirt. It doesn't matter why he put the spotlight on. Rick, you're giving a bad example. You're trying to make cops. People, pay attention. Keep your eye on the ball. Freaking crybabies. Okay, he did this because it was a warm night and Franklin was wearing a full-length camouflage jacket. Now, how do we know he did that for that reason? Because that's what he told us when he wrote his report. Could have been true. Maybe. If and buts coconuts. I don't know. I'm not Franklin. Or I'm not the officer. As the officer was talking to Franklin, he saw blood on his hands. For you people not in law enforcement, we call that a clue. And this ultimately led to his arrest for murder. Damn, he just got the guy for murder because he wore a jacket and had blood on his hands? That seems a little extreme. I'm sure there was other facts. A murder that had just occurred nearby hotel room. Okay, so, now, reading this, if I was writing this report, I was also on patrol, there was a murder in a hotel room. In this area, suspect was described as so-and-so wearing a camouflage jacket while driving eastbound on so-and-so boulevard. I noticed a man matching the description in a camouflage jacket on a warm night walking. As I spotlighted him, I saw blood on his hands. He matched the description of the suspect that was reported as fleeing the scene of the murder. I recognized him as matching that description. I spotlighted him, got out of the car, and arrested him. So that would have kind of been maybe what the report of probable cause statement said. Okay. A murder in rejecting the argument that the officer's actions resulted in a detention. So the defense attorney was saying, no, 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 no. When the officer shined a light on my client, he caused a detention. Therefore, and why is this important? Because the defense was saying, if in fact it was a detention when he shined a light, he wouldn't have known my client was wearing the jacket or had blood on his hands. Therefore, he wouldn't have arrested him. Therefore, if it wasn't a detention when he shined a spotlight, any evidence received or gathered because of that spotlight is now inadmissible, meaning the bloody hands and the jacket. So that's why the defense attorney wanted to make the spotlight meaning it was a detention, because had the judge ruled that way, the bloody hands and the jacket matching description would have all been thrown out. Therefore, it would have been missed. Now, we would have probably still got the guy some other way, because there's a thing that's called inevitable discovery. And if you can prove you would have got the evidence through inevitable discovery, through normal police tactics, you can get the evidence in, even though the court suppressed it in the way you got it. And let me see a case that would describe that. Okay, so there was a stabbing. There was a case where the stabbing, a guy ran from the area. And when they caught the dude, they didn't Mirandize him, and they said, where's the freaking knife? And he said, man, it's in the gutter. When I ran by, I threw it in there. That knife was suppressed because they had him in custody, in handcuffs, sitting on a curb, and they asked him where the knife is at, which is an interrogation on whether he's innocent or guilt in a crime without Miranda. Therefore, his statement, his answer was suppressed, meaning we can't use it. Therefore, anything we got from that statement, we can't use. Well, after he said it was in a knife, cops went back to the gutter and retrieved the knife. So it was like, oh shit, now we lost the knife. No, we didn't lose the knife. How did we give it? Inevitable discovery. Through practices in every crime scene, when there's a stabbing, etc., it is common practice and procedure for cops to do a neighborhood canvass where we look for people, we look for witnesses, and we look for evidence. And cops always check places that crooks would normally throw or hide things, like trash cans, dumpsters, gutters, drainage ditch, whatever. Anything that a crook on the run could have thrown, we would have checked. Therefore, we got it in through inevitable discovery. The court said, yeah, you know what? I believe cops normally do that. Somebody surely would have looked in a gutter from where they saw the guy running and would have checked the gutter for evidence. And you would have found it anyway. So we got to keep the knife. So that's why it's important. Let's see here. And rejecting the argument of the spotlight of the appellate alone fairly can be said not to represent a sufficient authority. So, and again, we talked about totality of circumstances, or what was the other term they used? The test for detention. There was a couple other terms they used. But again, would it seem odd that somebody lit somebody up with a spotlight? No. Now, let's change a fact for totality of circumstances. The officer was driving the other way, and the suspect was working toward him. And when his headlights hit him in the jacket, the officer pulled across the road facing the wrong way onto the sidewalk and lit the suspect up with his spotlight and bright lights. Now, do we have an detention? Absolutely, 100%. No ifs, ands, buts, or coconuts. That's a detention. You stopped his forward movement. You got in front of him and got out of your car with the lights blinding him in the direction he was walking. So you see how just one totality of circumstance can change whether a spotlight is a detention or it's not a detention. And that's the big thing that most people miss about law enforcement. When you get into trying to get evidence in a court, and you get into cases where you have really good defense attorneys trying to suppress your evidence, you better be dotting your I's and crossing your T's, or you're going to lose your shit. All right, so we got that through that one in 20 minutes. Here we go, next page. Oh, blocking the suspect. Damn, I just did that. Didn't even know this was next. Maybe this is different. Blocking a detention will result if officers blocked the suspect's path and it reasonably appeared that their purpose was to prevent him from leaving. Okay, in the scenario I just described, because he pulled across traffic, he was facing the wrong way in traffic, and he put his car on the sidewalk. Would a reasonable person think that I didn't want him leaving? Sure. Now, if I stopped my car in my lane and I saw him and I pulled over to the right, spotlighted him, and then got out of my car, I don't think we have an detention, even though I'm facing him. Again, totality of circumstance. That's why when people get out here and start giving these absolute opinions on what happened and who was right and who was wrong, and they know the law, you people need to, in the back of your mind, go, you know what? This guy doesn't know as much as he thinks he knows. Because there's too many facts that are unknown. There's too many things that we don't know what was in the officer's mind, what wasn't in his mind, what he knew, what was over the radio, etc. There's so many factors. All right, where are we at now? For example, People v. Wilkins, San Jose Police Department again. San Jose police officer was driving through a parking lot of a convenience store when he saw that two men in a parked station wagon had slid down in the seat as if to conceal themselves. For you people not in law enforcement, we call that a clue. Two guys trying to hide themselves when they see the cops. Well, Rick, maybe they dropped something and you can't do that because you're just being a boot. Whatever. Having decided to contact them, the officer parked diagonally behind the vehicle, effectively blocking him in. Now, I don't care if he's diagonal or if he pulled straight in behind him. If he's close enough to where this car can't back out without hitting him, then he's blocked him in. I don't care whether the car's diagonal or straight. I don't care if he backs in. So, to me, diagonally is not really a thing. I think they just put that in the court because, one, that's what happened, and two, it shows more of a blocking. People, especially a jury or other people reading, can kind of visualize a cop pulling in diagonally and blocking somebody in. During the subsequent encounter, the officer learned that the driver was on searchable probation. How did he learn that? Yo, dude, why you guys hiding? Anybody on parole probation? Driver said, I'm on probation. Okay. That's how he learned it. The officer that the driver was on searchable probation, and this led to a seizure of drugs. How did it lead to seizure of drugs? When you're on probation, you have no right to say no to search and seizure. You're searchable. Therefore, the car's searchable. Anywhere you're at, searchable. So as soon as you said he was on probation, get out of the car. I'm patting you down. I'm handcuffing you. Sit on the curb. Now I'm searching your car. You're on probation. I don't need probable cause. I don't need reasonable suspicion. I don't need shit. I can just search your car because I don't like you because you're on probation. And then when I find drugs, guess what? I can use it and it's admissible. That's what happened. But the court ruled that the evidence should have been suppressed. Ooh, because the officer had parked in such a way that the exit of the parked station wagon was prevented. Okay, so after all we've been talking, I want everybody to kind of ask themselves this question. Why did they suppress the evidence? The guy was on probation. The cop asked him if he was on probation, and we found drugs. Why would the court suppress that? Here's what your answer should have been. If your answer was anything but this, you screwed the pooch on this one. The reason it was suppressed is because the officer unlawfully detained him by blocking him in before he had reasonable suspicion. Because somebody ducks down on the car is not enough to detain. It's enough to be suspicious. It's enough to walk up and do an encounter. It's enough to go, hey man, what are you guys doing? That would have been fine. But you can't do that once you in de facto make a detention by blocking them in. So the officer detained them without reasonable suspicion to detain them. Therefore, the detention was unlawful. Therefore, fruits of the poisonous tree, anything that detention led to was unlawful. And that's why they suppressed the evidence. I think they should have let it in anyway because the guy was on probation. But even if he didn't block him in, the guy was on probation and he would have searched him. But we can't if and but and coconut that because they could say, the defense would say, well, what if my client would have started the car and decided to leave? If you didn't block him in, he would have left. And then he would have drove off and you'd have had no reason to talk to him and you couldn't talk to him because he was driving away. So how would you have found the drugs, officer? Well, I would have jumped behind his car and then when he hit me, I'd have pulled my gun, said he was trying to kill me, claimed off safety, shot him, and then I'd have found the drugs. Rick, you can't do that. You're a big bootleg. I'm just telling you what it is nowadays. Shit. All right. Court ruled, let's see here. In some cases, the courts have ruled that a detention did not result if the officer's car merely impeded the suspect's ability to drive. For example, People v. Perez, the court had ruled that the detention was not detained, the defendant was not detained since the officer parked his patrol car in front of the defendant's vehicle and left room for the defendant to leave. So we go back to that psychological. If a cop pulls in front of you and leaves room for you to leave, do you really think most people think I'm free to leave. I think that was a bad ruling, just from that comment right there. I don't care if he left the room or not. The officer's conduct was aggressive and was done with the intent to let those people know he wanted to talk to them. He pulled in front of them and he approached the car, even though he left room for them to pull around him. I think that should have been a detention. In my book, I mean, I'm going to have some cops. Rick, you're just picking over cops. You don't like them. I'll have the other people, let's see. Officer Park Patrol. Okay, and in U.S. v. Basher, the Ninth Circus ruled, although the officer testified that he parked his vehicle nose to nose with Basher's truck, this did not result in a detention because the officer testified that there was room to drive away. I'm calling bullshit on the officer, and I'm calling bullshit on his ruling. And I'm also going to take a wild-ass guess in my crystal ball that there was no videotape to this. Because if you pull nose-to-nose to a vehicle, just because the cop says there's room to move, doesn't mean there really is room to move. Rick, why you always pick it? Urgent interest. Urgent interest. That usually falls under exigency. Usually to prevent destruction of evidence, to prevent the evidence from leaving the scene, to prevent somebody from escaping, to protect life or property. A seizure may result if officers approached the suspect or his vehicle in a manner that demonstrated an urgent interest in him. Meaning, I get out of, I don't know what they're going to say here, but I'm just thinking, meaning, I get out of my car, I put my hand on my gun, I draw my flashlight, and I start hauling ass to you. Even though I said shit about you're detained, don't move, show me your hands. Even though I haven't done any of that. By me putting my hand on my gun, jumping out of my car with a sense of urgency, running over and shining my light on you, all that behavior, to me, dictates to the reasonable person, that cop's coming over here with his hand on his gun, he may shoot me, I better not move. And I don't think most people will think they're free to leave. But let's see what they say happened in this vehicle. Suspect vehicle in a manner demonstrated. For example, People v. Jones. Oakland police. Man, Oakland makes really bad case law. Those cops are freaking out of control. They deal with a high Black Lives Matter population, a lot of crime, a lot of violent crime. They hate the cops. Cops hate them. They get paid a lot of money. Oakland police is like, and I know a couple guys got out of the Air Force and won't work for them, and I'm telling you, man, looking at them 2 years after working there from when they got out of the Air Force, I would have swore I never knew them. I mean, it's just crazy how your behavior changed when you're working in a survival freaking combat zone. But anyway, Oakland police officer decided to contact Jones and two other men who were standing on a street corner. Contact, not detain. The court described the manner in which the officers rolled up. Ooh, a roll up. He pulled his patrol car to the wrong side of the road. Uh-oh. Wrong side of the road. Parked diagonally against traffic. Uh-oh. And about 10 feet from the group. Ooh, lots of little facts here on this one. The officer then addressed the men saying something like, "Stop." I'm done right there. That's a detention. He ain't got to do shit anymore. I mean, I was already detention before he said a freaking word, the way he parked and pulled up on him. But now he says, "Stop." That's a freaking detention. "Stop. Would you please stop?" Oh, he said please. So, see, there's officers out there that think if I say please, it's not a detention. Because if I say please, it's not a command. I'm asking. And if I'm asking, you can't be detained. There's a lot of officers that believe that. I don't believe that. And you shouldn't believe it just from these last couple of videos, because you probably have a better understanding of what constitutes a detention versus an arrest or an encounter than most cops do. Because they don't take time to read and study. All right, let's see. Would you please stop? At this point, he saw a baggie containing cocaine. Shocking. In Oakland, 3 men on a corner and a baggie of cocaine? Shit. He hit the lottery. He'll never find that. Probably again in 5 minutes. Let's see. At which point, he saw a baggie in the ruling that Jones was illegally seized. Okay, Jones, meaning was illegally seized. Remember, a detention is a seizure. When he said stop, he seized him. The court ruled he was unlawfully seized. Just because they were on a corner was not reasonable, articulable suspicion to say they were engaged in criminal conduct. When he saw the baggie, he had enough to detain them. But he had already detained him because of his actions, and he yelled stop. Let's see. The courtroom. The officer arrived suddenly, parked the car in such a way as to obstruct traffic. In another Oakland case. No shit. In Camote H, 2 officers saw Camote leaning into a car in a neighborhood where drugs were commonly sold. Okay, you can pretty much say that about any neighborhood if you drive around Oakland. There's very few neighborhoods that are really nice that you couldn't use high crime area. And even those areas are surrounded by high crime area. And I could say, although I wasn't in a high crime area, this neighborhood is located in the Central District and is surrounded by these different cities or these different boroughs or blocks or gangs or hoods or turfs, all known for high crime area. And these people in these high crime areas that circle this non-high crime area are known to frequently run, hide, and go through this area to commit and carry out their crime and unlawful acts. So I don't even need to say it was a high crime area. I can say you're in the middle of a whole bunch of high crime areas, which is the whole damn city of Oakland. But I digress. Let's see. Neighborhood of drugs commonly sold. Suspected a sale. Okay. And people who work drugs and work in drug areas know that most buys for drugs happen with one guy leaning in the car. Because if it happens outside, then cops can say, I saw the hand-to-hand Tron-Van. I saw the driver hand him something in a baggie, and I saw that guy hand him cash. Therefore, I saw a hand-to-hand transfer of money and or drugs or other contraband, and therefore I can take action. So most drug buys happen inside the cab. The crooks have learned this through getting educated through their public paid defenders with your tax dollars. They have learned how to commit crimes without making it easy for the cops to arrest them. So they lean in the car. Therefore, no cop can ever say, I saw a hand-to-hand buy. All I can say is most drug buys happen this way because of this, and this guy was leaning in car in the middle of a street in an area known for high crime, and his activities were the same as a lot of other drug deals that I've seen going on. And that's how you would justify around that. Let's see. Car stopped approximately 15, 20 feet away from Coney. Walked toward him at a semi-quick pace. Okay, somebody quick. Write down or justify what a semi-quick pace is. Go ahead. I want somebody to articulate that. Okay? If I had to, what is a semi-quick pace? Well, it's not slow and it's not fast. Okay? How much slower or faster is it closer to? Well, it's quicker than a walk, okay? Slower than a run, okay? So anything that's not slow or fast is semi-fast paced. Is that what you're telling me? So, I mean, you know, when you use terms like this, cops think they're being slick, but when you have to get on a stand in front of a jury and have to explain this, you may not seem so slick. Where the hell were we? I should leave my mouse where we're at. Coach are 15 feet away. Semi-quick pace. The ruling that the officer's actions did not result in a detention. We're at 33 minutes. I'm about to stop. We're almost done here. Did not result in a detention. The court said that a reasonable person would not have felt restrained by 2 police officers approaching him in a public street, especially in Oakland. Because when the cops get out in Oakland, let me tell you something. People in the hood, they know how to not hang around when the cops are there. They know how to avoid the cops. They know how to not talk to the cops. They know that when the cops show up, ain't nothing good going to happen. So people in the hood are a lot smarter than so-called good citizens that want to run around and get along with the government and be their friend and help them. Let's see. A reasonable person would not have felt restrained by 2 officers, especially in the hood. They don't give a shit how many officers you come. I'm running. And that a reasonable person could only conclude that the officers wanted to talk to him. Surrounding the suspect, a detention might also result if multiple officers on the scene effectively surrounded the suspect. The suspect is covered in a section of officer safety measures. And I agree. When you circle a guy, you are not telling him he's free to leave. When you block his path, he's not free to leave. When you stand in the doorway in a room he's at, he's not free to leave. When you put a chair in a corner and you have 3 officers standing in a semicircle with his back to the corner, he's not free to leave. So there's plenty of ways to communicate you're not free to leave without saying you're detained. And cops try to be slick. Go, oh, no, he wasn't detained. He could leave. He was just handcuffed to the chair because I didn't want him to steal the chair. Okay, I got it. You're free to leave. It is significant that officers told the suspect that he was free to leave. Although such notification is not required, it is recommended, especially in closed cases. Closed cases meaning if you're pushing a limit and it's iffy. If you ever think that you're dealing with a suspect and you're trying to establish or create or find or articulate reasonable suspicion to go farther to detain him, the best way to make sure nobody's confused that he's detained is to say, hey, dude, you're not detained and you're free to go. There's no question whatsoever that any court's going to rule that if you say that and you're not doing a whole bunch of other shit. Now, again, if you're blocking him in, he's in handcuffs sitting on the curb and you say that, then they're going to call you a freaking idiot. It is recommended. Also note, any qualification on the suspect's freedom to leave or otherwise terminate the encounter will likely result in a detention. Okay, let's read that again, especially in close cases. Also note that any qualification on the suspect's freedom to leave or to otherwise terminate the encounter will result in detention. I'm not really sure what they're trying to say there with any other qualification. I'm thinking that if the suspect in any way, shape, or form asks, requests, or tries to leave or terminate the encounter and you stop it, it's a detention. And that's the way I would say it. You can leave after you answer questions. That's a detention. Absolutely. You can leave after you answer questions. Again, that's slick cop double talk. Oh, I'll just tell him he can leave, but then I'll imply he has to answer questions. But I told him he could leave, so therefore I'll be good. Well, that's because you're an idiot, and you're out there trying to be slick, and you don't know what you're doing. You can leave after you answer questions. No, finally, a free-to-go advisory is virtually irrelevant if officers conducted themselves in a manner that reasonably indicate that the suspect was not, in fact, free to leave. Now, I have to go, if you say you're free to go, and the suspect doesn't try to leave, I think you got pretty good cover. Now, if you say you're free to go, and as soon as he makes an attempt to leave, stand up, or walk away, and you move in front of him, or you go, you don't want to do that, or that's not a good idea, or you might want to hang around and hear what I have to say before you do what you think you're going to do. Now, anything like that, now obviously we're moving, you blew it, just because you said you're free to go. All right, we're at 37 minutes. Hell, am I going to make a part 4 on this shit? Officer safety. Requesting ID. All right, well, shit, I just might go through the whole damn... All right, we'll end that there. Here comes part 4.